Archiving started.
Hello, everyone. Welcome to Chapter 5, the Physician-Patient Relationship. In order for there to be a relationship that's even established, both of the parties, the physician and the patient, have to form a relationship, which is a sort of a contract, an implied contract. And it would start out with the patient calling the office for an appointment and being accepted, going in for that appointment, and seeing the physician. That is an implied contract. It would be the same if the patient were to go into the emergency room and to be treated by a physician. Under contract for services, a patient can expect the doctor to provide medical service for as long as necessary. Of course, the physician has to confide truthfully. The patient has to confide truthfully to the physician, otherwise they can't expect to be treated appropriately. That second thing here that I said under contract, under contract for services, the patient can expect the doctor to provide medical service for as long as necessary. That is true. We'll get into a little bit later on what happens if the doctor wants to pull away from the patient in an appropriate manner, giving them a certain amount of time to find another provider to care for them, sending it in, with a written notice, return receipt requested. Otherwise, it's considered abandonment. So nobody wants that to happen. Now, the physician does have some rights, of course, as does the patient. The physician has the right to decide who they will see. They have a right to refuse to provide service to patients. For example, some physicians do not accept Medicaid. I'm not saying it's right or wrong, it's their choice. They have the right to determine the type of service they'll provide and the right to be paid for those services that they do provide or render. They have the right to withdraw, as I had just mentioned, from a relationship appropriately, and they have a right to vacation and time off, of course, as long as they provide someone of the same type of certification to cover for them. Otherwise, that's abandonment also. And a good example of this is that they're a OBGYN and they're on call to deliver babies. They can't very well have an orthopedic surgeon covering for them just because they carry the title of MD. Has to be someone of like specialty. Now, moving right on, the responsibilities of physicians, this comes directly from the American Medical Association Statement of Principles, and they're responsible for continued study. They have to have certain CMEs every year. They have to agree to keep everything confidential. They have to be honest and have human dignity, and they have to have a responsibility to society. That's at the minimum. We would certainly want that from our physicians. And some of the other responsibilities are they do have freedom of choice who they're going to take care of and where it will be. One of their responsibilities is to improve the community, doing some sort of community service free if necessary. They have to agree that the responsibility to their patient is of paramount importance, and they have to provide access or support access to medical care for all people. Now that says all people, even Medicaid. If they're not willing to take care of patients that have Medicaid insurance because they just can't afford it, they have to be able to refer them somewhere that they can be cared for. And almost I believe every emergency room has to at least take care of a patient and get them to be stable before they would be allowed to move them on. So the professional practice responsibilities, this is during a medical emergency. They cannot ethically or legally turn the patient away in an emergency. If they're unable to treat the patient because of their specialty differing from what is obviously needed, they must call for emergency assistance. They cannot be turned away if they're indigent or uninsured. Medicaid would be for the indigent. They can't turn them away. Now, I had just said before they can choose who they will take care of, and that's true under usual and customary and reasonable daily practice. But if it's an emergency, that's an entirely different situation. They must stabilize, treat and stabilize. So on that note, the duty to treat indigent patients, the dumping crisis is not looked upon favorably. Dumping means you take someone and say, I can't handle them, ship them on to the next hospital. Not permitted. If it's found to be going on, there's a penalty and a fine. There is that right that the patient, that the physician has the right to treat whomever they want, except in the emergency situation. So understand that the physician has the right to select the patients that they will treat on a routine basis. They do not have the right to drop or abandon patients once they agree to treat them, again, unless it's done appropriately, which is by certified mail, return receipt requested, giving the patient adequate time to find someone else to care for them. So their duty is not to abandon the patient, obviously. So they have to terminate their contract, implied contract, properly, not improperly. If they do it improperly, they may be sued with abandonment, and if the formal notice is not given, or withdrawal of care from a patient, that would be hard to disprove. The patient must allow the physician must allow the patient to seek the services of another physician, giving them time to do so. So now the question is, what happens if there is a patient that has AIDS, HIV or AIDS? It is unethical to refuse to treat, work with, or provide housing for a person who is HIV positive or who has confirmed AIDS. By law, the physician has to make a full report to the State Department of Health about any patient who is HIV positive or who has AIDS, but that doesn't mean that they can't treat them, work with them, or provide housing. I'm not saying that all physicians provide housing, but let's say they have, a sideline where they have apartments and they choose to rent to someone. If they find out they have AIDS, it does not mean that they can refuse it. So some of the ethical considerations when dealing with or treating an AIDS patient, if this is interesting, but this is what the patient is advised. They have to try to persuade the patient to inform their partner or partners so that the buck stops here and it cannot be passed on. The authorities, the State Department of Health, has to be notified, and they also have to be notified if the patient says that they're not going to inform their partners or partners. So if the doctor is concerned about that potentially happening, you have to let the authorities know that. And the authorities, and I say I don't mean the police, I'm talking about the State Department of Health, they would go on a search to find out the tier of who this person has been with in order to inform them. They have a right to know. And as a last resort, if the patient will not inform their partner or partners, and if it has to go to the authorities, if the physician were to come across the patient's partner or partners, they may have to inform them themselves. This is one of the absolute last resorts, and it would be appropriate to break confidentiality in this case, not just because, and it's not to just anybody, it's directly to the patient's partner. Now, the ethical considerations being said, let's go on to exposure of healthcare workers to patients' blood. There's a very small risk, a 0.3% risk of contracting HIV after blood exposure. According to the Center for Disease Control, you cannot get it from just casual contact. It usually is not in urine or in saliva or in tears. However, there's a small chance that it may be. The HIV testing of patients' blood is allowed in some states, especially if there's a trauma and the patient were to come into the emergency room. There's not time to ask them if they give their permission. It is automatically allowed in some states. There would be, with the trauma, a tremendous amount of blood around, and it's good to know, whether the people caring for them are safe or not. Duty to properly identify patients. I don't know about you, but I have been recently in the hospital, and my husband also, and I think every single time they walked into either one of our rooms, they asked our full name and our date of birth. Also check the identification band. It seems like it's a pain in the neck to do that, but I'd sure rather have that than to have a patient misidentified. Hello, my husband. Use discretion with patients. Sign-in sheets to protect confidentiality. Don't just leave it out on a countertop or a table for anyone to see. Certainly turn the papers over. But always have the patient state their name and their date of birth and check the armband. So, the duty of the patient to tell the truth. Many believe that the principles of justice will apply when dealing with a truth-telling patient or doctor. If they are lying, all bets are off because you can't prove what you've done is appropriate. So you have to try to determine what is the just or correct action for the patient, assuming they're telling the truth. Some of the just actions may be at a variance with an obligation of confidentiality. That means if they have something that is communicable, it has to be reported to the State Department of Health. And in the case of HIV or AIDS, if the patient will indicate that they're not going to tell their partner or partners, then the physician will have to do it. So that's one of the cases where the confidentiality may be overridden. The patient's right. They have the right to give informed consent. They're speaking and saying, go ahead, you may go ahead and do whatever, such and such. They have also to the ability to sign for it. Implied consent is different, and it is also assumed that if a person were to come into the emergency room at any time and they're unable to speak, it is assumed that they want their lives saved, so that's implied consent. Rolling up their sleeve to have a shot, making an appointment to go into the doctor to have a colonoscopy, even though that particular procedure is signed for, those are examples of implied consent. They do have a right to privacy as patients. They have the right to be informed of advantages of their procedures or treatment and any potential risk of treatment. So it's a situation where they need to know the best and worst case scenarios. Now, the patient does have the right to refuse treatment. It may not seem intelligent to do so, but they do have that right to refuse it. And they have the right to expect confidentiality. It's called privileged communication that the patient has directly with their physician. It's the same kind of thing they have with their lawyers or their clergy. This is privileged communication, and they are protected under the confidentiality clause. So what is confidentiality? It says simply that all information and records about treatment of a patient will be kept confidential by the physician and staff unless there is a signed consent release obtained. It's not okay that it's just verbal. It must be signed and also put into the patient's record. The Medical Patients' Rights Act says that all patients are entitled to have their privacy respected at all times and their medical records handled confidentially. I know you've worked on a couple of cases this past few weeks that the physicians have or nurses have let confidentiality fall by the wayside, and the medical records have not been handled confidentially, which is not a good thing. Another thing about confidentiality, that privileged communication I was mentioning, states that information told to either a physician or attorney by a patient must be kept strictly privileged. HIPAA regulations have to be observed, and you will get more about that as we get into Chapter 10. Now, what is the Patient Self-Determination Act? This says that the patient may have an advance directive, which says who can speak for them, whether they wish to have any extraordinary measures taken should they require them and they're not able to speak. They have a right to have a living will, which also includes the do not resuscitate order. As I mentioned, no extraordinary measures taken to keep them going if they have certain things that are not met, like if they have no brain activity, they don't, and the person has decided in their mind that they don't want to be kept alive on machines. They have that right, and it must be respected. They have the right to sign a durable power of attorney, which states that someone can take over and sign for them should they become incapacitated or incompetent and cannot make those decisions. And then the Uniform Anatomical Gift Act says that the patient may decide if they are going to be an organ donor upon their death. This is on their license at this time. Now, the patient, obviously when they're dead, they can't revoke the document, but let's just say they decide beforehand, I don't really want to be a donor. They can go and change that on their license. The family, however, if the patient is deceased, the family may consent on their behalf to have them be organ donors. I saw a really interesting bumper sticker, and it said, "Why take your organs to heaven when we need them here?" I think that's pretty appropriate. Now, what's a minor, you might say? A minor is any person under the age of maturity, and in most states that is the age of 18. There can be something that is called an emancipated minor, where the patient has been responsible for their own care and decisions, and they go before a judge and say, I am mature, I am under 18, but I would like to be able to make my own decisions separate from my parents or a guardian. And if the judge grants that, they are considered to be emancipated minors. In loco parentis is a person who is assigned by the court to stand in place of the parents if someone is a minor and they have not applied for emancipation. They are obviously taken away from the parents for whatever reason, a parenting issue, and the court will apply in loco parentis. This just happened with Michael Jackson's 3 children. The grandmother who was, upon Michael Jackson's death, the grandmother was given sole rights to raise these children. She went away for a couple of days, and the whole thing blew up. The family some knew what was happening, some didn't, and for whatever reason they had an uncle given the sole right to take care of the kids, and I'm sure that the grandmother, now that she's back, will go to court and receive the right directly back. It's a whole mess. But more about minors here. What is a mature minor? Person in mid to late teens who, for health care purposes, is considered mature enough to comprehend what the doctor is saying and give informed consent. So if someone's 17 and they go in for whatever care, they can go ahead with what the physician says without having to call their parents in. And as I had mentioned, an emancipated minor, a kid who's in their mid to late teens who lives outside of the parents' or guardian's control, they petition a judge and become an emancipated minor. Now, what are the patient's responsibilities? Their responsibility is to follow the physician's instructions. They cannot violate all of the physician's instructions and then expect to sue if they don't get better. They have to make follow-up appointments. They have to have their treatment monitored. They have to use the medication that has been prescribed if it is requested that they do so. They have to be honest, which I've mentioned several times, with the physician. They have to pay for their medical services or whatever it is not paid for by their insurance, and they have to provide informed consent for procedures or any treatment. Consent is the voluntary treatment to allow any medically trained person to touch, examine, or perform treatment. And there's 2 types. Informed, which is an express consent stated to the patient so they understand the pros and the cons, the risks and the rewards. And then there's implied consent, saying that they really don't know what's going on, but it's assumed that you want the physician or any medically trained person to save your life. And that includes CPR or the Good Samaritan Act statute being performed out in the field. It also is assumed if you go in for a blood test into the lab, you've made that appointment, you walk in, you roll up your sleeve, and that's implied consent. So what are they? Just it's stated for you here. A patient agrees to the treatment after being told of the consequences, the risks, and the rewards of having or not having certain procedures or treatments. And a signature in that case indicates that the patient understands the limits or risks that are involved as explained by the physician. Now I want to move on to the doctrine of informed consent. It says the physician cannot talk in the medical mumbo-jumbo that goes on. They have to speak in language that the patient can understand and process. They have to explain the advantages and risks of treatment. They can use pamphlets. They can use drawings. They can use words that, I don't say dumb it down, but words that the patient can understand. They also have to be able to provide any alternative treatments to the patient. They must tell what the potential outcomes are and what can occur if treatment is refused. Implied consent, the patient indicates by their behavior that he or she accepts procedure, and as I mentioned, offers their arm to have a blood sample, rolls up their sleeve to have an injection. Consent is always assumed in medical emergencies when a patient cannot respond or give consent. There are some exceptions to consent. You need not inform of commonly known risks. You don't have to inform if the disclosure of risks may be detrimental to the patient. And they don't have to inform the patient if the physician says, don't tell me. I don't want to know what the risks are. There are some more exceptions. They don't have to require, the physician is not required to restore the patient to their original condition or health. They can't cure every patient, and that has to be known. And they can't guarantee the success of every treatment. There is refusal to grant consent. Adult patients that are conscious and mentally capable have the right to refuse any medical or surgical treatment. And that refusal has to be honored no matter what the patient's reasoning may be. The failure to respect the right or refusal could result in a liability of the physician for assault and battery. Possibly the only time that this would be not the case would be if the patient were not of sound mind or competent and they had signed the advance directive where they have someone who can be their advocate. And lastly, the role of the healthcare consumer. Do not self-medicate. Of course, be honest with the physician and assist the physician in the prevention of any medical errors. I had wanted to say some examples of, just to go back for a moment, some examples of implied consent. Nonverbal communication, meaning that it's looking as if they want you to take care of them by rolling up their sleeve or extending their arm. They make an appointment for a recheck. That's an implied consent. If the patient signs a HIPAA form, that's an example of informed consent. It's not just implied, it is informed. I wanted to say when a doctor is not required to disclose information, I had said, there have been 2 slides here that pretty much says what's going on. But if it will hurt the patient, then the doctor may not have to disclose it. And I don't mean just hurt them physically. If it will hurt their chances of recovery and it doesn't need to be disclosed. Let me see. All right, so suppose about confidentiality, to go back for a second, I think pretty much everyone has read in our discussion forum that if someone were to approach a medical provider, whether it's a doctor or a nurse or a lab person, and ask for the results about somebody famous who's come in, can any information be disclosed? And the answer to that is never. Not unless the person wants to be sued for a breach of confidentiality, which is a huge, huge HIPAA violation. And that's about it for today for Chapter 5. I sincerely hope that this helps you, and please let me know if you need any additional help with anything else. You take care. Have a great day.